So basically the idea today, this is Ashish sir's idea. So we have already learned about POXO Act, the Bail Act. We have learned about uh, the related forensics that we had to learn about. We've learned about DNA as well. Now we are going to combine the two subjects and try to see how can we tackle experts in a court, and how we can use what the knowledge that ma'am has imparted on science and sir on POXO, how we can use that efficiently when we have an expert in the court. And in sir's words, they move in the court like a king and they go out like a king, and no one touches the experts. So we are here to kind of get an insight how to roast the kings and queens and try to corner them a little with the new things that we have learned, which many of the people out there in the market, actually most of the people don't know. So here what we're going to do is we three are going to play the prosecutor, the expert, and the defense. I'm going to be the prosecutor and the one with the shortest script, and then there's going to be ma'am with who will be the expert, of course, and sir defense. And in between we'll have commentary by sir ki kya karna hai, kaise nahi karna hai, kaise karna hai, and questions. And then some experiences that ma'am and sir have had in complex situations, or whatever we can learn from their experience. So I'll give it up to sir now, and sir uske baad fir I'll just put up my screen and we'll start with the questions.
So
Okay.
before you start, I just want to put a disclaimer. This is a room full of the other side. This room is full of the other side. I'm the only one on this side. So be gentle, be kind, and I will do my best. But that is the disclaimer.
Okay, so I will put an even bigger disclaimer to add to what Raghav was just saying. Experts, now this is something which comes out of experience as well as what I have seen in courts. So, and this is not only a disclaimer, it's a preface to what we are going to do today. There are two things when one looks at expert evidence. One is that one generally finds amongst judges and even amongst the expert community as such, that the opinion of an expert is valued a lot. Okay, now that is expected because that person is an expert. But sometimes it does happen that it goes on the borderline of being venerated. It is almost like a god. So a god coming to the witness box and saying that this is the gospel truth. And very rarely you find sound and scientific cross-examination. The cross-examination that one normally sees, I mean, when I say normally, I'm saying most of the time. Many times we do find excellent and very incisive and very fruitful cross-examination. But most of the time, defense lawyers leave these expert witnesses alone, primarily for two reasons. One, because they themselves are diffident about facing experts on their own turf. And secondly, because the courts and the entire judicial process is in a manner accepting the truth of what the witness is saying. So it becomes a challenge for the defense lawyer to dislodge the opinion that is formed in the mind of the judge. So when the judge looks at an expert, he says, or he has this picture in the mind that here is a person who is an absolute expert in his or her field, and any question related to that field is not going to be easy to pass the test of the judge. So he would probably overrule it, or he would say that, okay, you are asking irrelevant questions. So this is one of the mental blocks that the defense lawyer has to overcome. And today what we are going to demonstrate is some questions, a little bit of commentary from my side, in which the whole process one will also learn how to prove an expert opinion, or any opinion for that matter. Ayushi, you have been asking about suggestions. So at the end of it, I will put my case to madam, and you will learn why suggestions are so important and why they would play a very relevant or important role in you are marking your final. So I about which madam will tell us in just 2
Ashish, sir, I think you're
minutes
not clearly
so
audible.
for
Is
that
that just
report.
me or
So that
everybody?
report will prove madam. So madam is the expert
Ashish sir, you're
witness
not audible
and she's going
properly.
to prove the report. I'm not audible. Okay, wait a minute. I'll just change my internet source. Just give me a second.
Yes, sir. You'll have to repeat the last 2 or
I'll
3
just
minutes.
change. Now is this better?
Yes, sir.
Yeah. So I've changed my internet source. So I guess. So what did we
Yes,
miss?
sir, we didn't hear the last whole paragraph.
Okay, so basically what I was saying is that today what we are going to do is to attempt to give you a kind of a mock demonstration as to how an expert witness enters into the witness box, proves his or her report through the examination in chief by the public prosecutor, and what kind of questions can be asked. Of course, these questions will also be followed by some commentary. So these are not some, magical questions. They are questions coming from that report. And then we will also follow up with the suggestions which are given at the end of every case. And I'll tell you why those suggestions are so very necessary. Madam, can you tell us about that report that we are going to prove today? Just in half a minute, maybe. What is that report about?
So basically, it's your case, right? So if you maybe want to just give them a gist of the case.
Okay, so this report, what I think we can share the screen, somebody of us, so that they can see the report, and then I can talk. Yeah. Okay, so we will have just this one slide basically. Now, what basically this is it's a DNA report. Now, what is this DNA report? The purpose of the DNA report is to establish the paternity of a fetus or a child. Now, the background of this case is that this is a POXO case where the girl involved was obviously a minor. She was subjected to sexual assault, which was the case of the prosecution. And out of that assault, she conceived and ultimately she delivered. So the obviously the golden test was to find out, or rather to establish whether the assault has taken place or not. The golden test was to show whether the accused was the father of that particular child, and this report ultimately establishes that he was the father of that child. So therefore, this is a positive report in that sense of the term. So then we can now start, I believe.
Okay. Should
Okay.
ma'am, should
Just
I
to
share?
add, sorry,
Yeah.
just to add one thing is that everybody was furnished with these documents earlier today. So you may want to follow the chain of the documents as well on your personal device, because the presentation that we are sharing with you may not necessarily be in showing all 8 or 9 pages. So if you can open up whatever we sent you as well, then that will help you follow a little bit better.
Okay, so madam is now under oath. She is in the witness box, and Raghav is the public prosecutor who will now take over from here.
Yeah, I'll just take a second, ma'am. I think I'll uh, present the
Screen
screen.
share it. Yeah, you can screen share it. Madam, you can stop screen sharing.
Okay, just give me 1 second. Also, guys, today you guys don't have mics, for the first 1 hour that we'll be presenting. In case anyone has very relevant question, you can raise your hand and then you'll get the mic. Nahi to we'll take all the questions after we are done with all this. Then we'll take questions aram se. Can everybody see the screen?
Yes.
Yes, we can see the screen.
Oh, just a second.
Can you make it a little bigger, because on my screen at least I can't read what is there. That is the best. Yeah, this is better.
Better now?
Yeah.
Okay. So starting off, me being the prosecutor, I am just gonna ask some questions to ma'am to clarify what the report is about, and then we'll carry on. So, madam, the first question to you that I have is for you to tell the court, have you prepared the report that we have on the screen right now?
I am the recipient of this entire report, but I have not authored this entire document.
Okay. You know about this report, right?
Yes.
And all of these documents.
I'll just pause here for a minute. Raghav, can you please show madam the whole report so that she understands which part she has authored and which part she hasn't authored?
Yes, sir. Coming on to that. Yeah. So, ma'am, I'm showing you all of the pages that we have. We have around 8 pages on the screen. I want you to tell us if this is the document that we are talking about, and if there is anything that you have authored.
Yes, sir. I am the author of pages 1 to 4. I am not the author of pages 5 to 8.
Okay, so we have this first page, second, third, and fourth. This is what you have authored.
Yes.
And the rest of them, you are the recipient.
Yes.
Okay. All right.
Technically, I should have objected to this. Because Raghav, you asked leading questions.
Okay.
So this is lesson number 1. In the examination in chief, you can't ask questions which end with yes or no. So when you say that, are you the recipient of this document? And the answer is either yes or no, then it becomes a leading question. So you could probably reframe it by saying, what comments do you have to offer on this document?
Okay, right.
That could be a clue for madam to say whatever she wants to say, whether I have authored it, I have not authored it, whatever. But this is lesson number 1, especially Ayushi, if you are listening to this, please pay proper attention, because these are the small things where defense lawyers can take objection.
Right. And everybody please stay on video so we can see you nodding and understanding. And if you have any question, anything relevant, you can raise your hand. Okay. Next up, ma'am, could you please identify whose signatures are there on the pages that you see in front of you?
On this page, that is my signature.
Okay, moving on this one.
On page 2 at the bottom, that is my signature.
Here.
On page 3, that is my signature. On page 4, that is my signature.
Moving on with the rest of them.
This is not my signature. This is not my signature. This is not my signature. Nor is page 8 my signature.
All right. Have you gone through all these pages?
I have gone through the contents of my report, page numbers 1 to 4.
Personally?
Yes.
All right. So these records, I request the court to be exhibited in the records. And so these are the original documents that I had to put before the court, and we can move ahead now.
Okay, now some comments from my side. What you just saw was the public prosecutor doing 2 things. One, he introduced a document in evidence. He asked the author of that document, namely the expert witness in this case, whether this document was authored by her. So she answered in the affirmative. Then he took her through every page and showed her if at all her signatures were there on the document. She answered in the affirmative. He also asked her about the contents of the document. She said that these contents were prepared by her. And he also asked her whether they were true and correct. And she has answered in the affirmative. So when a document which is an original, so we are assuming that this is an original document, where the author is in the witness box and the author testifies to her signatures being made by her on that document. She also goes through the document and says that the contents are true and correct, and that she herself has prepared the document and she's personally aware of the content of the document. When these 4 or 5 ingredients are fulfilled, what we say in law is that this document is proved. Once this document is proved, normally it gets an exhibit number. It could be anything. It could be P1, P18, 25, depending on how this administratively the exhibit numbers are given. Okay, one more important point is that only because an exhibit is given, the document is not proved. So remember one thing, that exhibiting of a document is an administrative act. It is not that once you exhibit a document, automatically it means that it is proved. It is proved only when those 4 questions which Raghav asked and 4 or 5 questions which Raghav asked and which were answered in the affirmative by madam. Had this not been an original, what would have happened? The defense lawyer would have got up and said, this is not an original document, this is not direct evidence, there is no application for leading secondary evidence, hence madam can't go ahead. Please produce the original. What would have happened if madam had said that this is not my signature, even in those first 3 or 4 pages? Then the defense lawyer would have said, in that case, this witness has not authored these documents, and therefore these documents can be produced in court through this witness. So that is one golden rule. You have to first see whether the documents which are being tendered in the court are primary evidence, whether the person who is tendering them is the author of the document, because in expert witness evidence is not, it's not going to be a recipient, it's always going to be the author. So whether the person is the author of the document. Had madam said that I am not aware of the content of the document, although I have signed it, my junior has prepared it, then obviously the first point that a defense would have raised is that she is not aware of the content of the documents. But madam did not say anything of that sort. She said, on the contrary, these documents are made by me, I am aware of the contents, all these initial criteria was fulfilled, and therefore now these documents form part of the court records. So now I can go ahead and cross-examine her on these documents. Okay, now there is one thing that I was discussing with Raghav when we were sort of preparing for this session. Rajesh ji has a question, fine. But before that, let me complete what I started. So when we were having a discussion, I told Raghav that many a times I have noticed that prosecutors do ask a last question after all these mandatory questions which are necessary to prove a document. And that question is that, madam, go through your report and please tell the court what is there in that report. Okay, now this is a little bit of brainstorming that I will do. It's my personal opinion that this last part is not necessary. The last part where you say that please go through the document and tell the court what does this document say. Now, according to me, it is not necessary. In fact, it could be sometimes counterproductive. Now, I'll explain myself. What do I mean when I say that it is not necessary? If you go through the Evidence Act, you will find sections which will talk about exclusion of oral by documentary evidence. So if there is a document which is tendered in court and the document is proved properly and it is exhibited in the eyes of law, then it is read as it is. So that is what we say when we that is what we mean when we say that document speaks for itself. So no further evidence needs to be given of that document, which speaks for itself. So technically, even if Raghav stops at the point where he actually stopped, this entire document will go on record. It can be read and appreciated by the court. Now, what happens practically when you ask that last question? The witness will then try to paraphrase, interpret, or speak about the report in her hand in the manner that she wants to speak about. So, in a given situation, the witness might say some things, she might leave some things, she might say some things more explicitly than the other things, she might not say some things at all. So, according to me, it's a risk that the prosecution takes when it asks such a kind of question that please talk about your report. The document is there for the perusal of the court. The document has been proved in the eyes of the Evidence Act. The document can speak for itself. So according to me, now of course, there may be a school of thought which would say that let us ask this question and get it from the witness. But if I were a public prosecutor, I would have shied away from this question because it might involve the witness saying something which might be a little bit discrepant here and there. So why take the risk? Okay. So this is my little 2-bit thoughts on what Raghav did just now. Now I'll start with the cross-examination.
Rajesh ji has a question.
Yeah. So before I start with the cross-examination, just unmute Rajesh ji.
Sir, good evening, sir.
Good evening.
Sir, this initially when Raghav was, asking question, you said it's a leading question. So he reframed the question. You suggested that reframe the question. What do you have to say about the report? Similarly, in the last question, I think he asked was, have you prepared something? He asked fourth question. I think again the answer could have been yes and no. So,
I got your point. I got your point.
So my submission, sir, and Raghav, you don't mind, it's education for us. I would expect, sir, wherever in his asking, you feel objecting, please educate us that it has to be rephrased like this. It will be education for us. Don't
Correct.
take
So
it
therefore,
personally.
So therefore, I took the right objection at the relevant time. And
because even the last question, it could have been answered, could have been yes.
Correct. I didn't want to, repeat the same objection. But wherever, so the golden rule is this, that you cannot ask leading questions in examination in chief. So I didn't want to overemphasize it. I emphasized it once. So that's why it's only this thing. Otherwise, I could have taken an objection at all the leading questions that were asked by the prosecutor. Yes, Ayushi.
My only submission is, sir, in case you can correct it, rephrase it like this, it will be a learning for us. That is my submission.
Correct. So the way it has to be rephrased is that you cannot ask a leading question. So how would you address it? You would ask it by asking an open-ended question. If I say that, would it be correct to say that the color of your t-shirt today is blue? You would have to answer it in yes or no. But if I ask you, Rajeshji, what is the color of your t-shirt today? Then I'm giving you an opportunity to explain. So therefore, it's a non-leading question. Okay.
Now, also, sir, in initially when you suggested that instead of asking, have you prepared this report, or what do you have to say about this report? Isn't it? You said something like
No, I said that you don't need to further ask the witness after proving the report.
No.
After proving the report, you don't need to further ask the witness to verbatim repeat what is there in the report. That is not necessary. That is what I said.
No, initially when you call the witness in examination chiefs, you will definitely ask him, what do you have to say about this, isn't it?
No, you don't have to ask that for the simple reason that there are 4 ways that a document is produced in court. Once the witness says that it is her signature, once the witness says that she has gone through the document and she only has prepared the document and she is aware of the contents are true and correct. The page, every page where she has signed has been shown to her. If you notice, that is what Raghav did right at the very beginning. Okay. So if all these ingredients are fulfilled and the document is exhibited in court, then the document can be read as it is by the court, right from the first word till the last word. Correct. So therefore, there need not be an subsequent explanation in the examination in chief given by the witness as to what this report is about, what it says, where were the samples, what were the findings, which were the methods used. It is not necessary, because once a document is on record, it speaks for itself. And the principle that we go by is that the exclusion of oral documents by documentary evidence. So oral evidence by documentary evidence. So where there is documentary evidence, you don't need to specifically say. I'll give you a very simple analogy. If I prove a letter which is written by Rajesh Tandon to Ayushi Mishra, and Rajesh Tandon is in the witness box, and the letter is proved, those 4 ingredients are there, Rajesh identifies his signature, contents are true and correct, etc., etc. Then what is the purpose of me asking Rajesh Tandon, please tell me what is there in the letter?
Got it, sir.
Purpose.
But the only thing is, sir, initially when the expert witness comes, you have to ask him some question to, you
Those
not
five
start rattling out, these are my signatures, these are not. Some question which is not a leading question. Now,
obviously, so Rajeshji, you have been following those 5 or 6 questions which Raghav asked, right? Those were the questions which were needed, which needed to be asked.
Okay. Right.
Okay. Ayushi?
Sir, actually, ma'am said that she has authored only the first 4 pages.
Yes.
And the rest of them she hasn't. And she has signed
Correct.
only the first 4 pages. So
Correct.
only those 4 pages would be exhibited, or the entire 8 pages?
Obviously. Elementary. Obviously, the first 4 pages would be exhibited.
Okay,
Which is why I got this purposely done, so that you understand that where a witness is not the author, those documents can't be exhibited through her. This was particularly for your, for the audience's benefit. I purposely put in those documents which she has not authored.
So either she should be the author, or she should be aware of the contents of the document.
Or she should be able to identify the signature. See, the second part is sometimes there is a situation where the expert may be changed. Now, Riva Pocha, fortunately, is the same lady who has done this whole report. But supposing this case comes up after 10 years, where Riva Pocha has left the organization, and there is some other person who's there. So obviously, you can't insist that only that person should come, because that person is no longer available. So what is the way out? The way out is that that person who comes is again authorized under CRPC to be the expert witness. He comes and he says that this report is prepared by Riva Pocha. I was working with her or him at that time. I identify the signature, and I also identify the contents, they are true and correct. And I have myself carried out, or I am myself personally aware, although I may not have carried out the test, but I'm aware of what this test is all about. So this is the way that that other person could prove the report. Okay. So can we go on with the cross-examination?
Yes, sir.
Okay. So, madam, now I will screen share so that I can control that document. So whoever is screen sharing, just stop. Okay, so this is what I normally do when I start with my cross-examination. So, madam, I am going to ask you a very few questions. I will not take much of your valuable time. You are a very busy person, I am told. And this will not go on for more than 10 or 15 minutes. I'll just ask you very few, but what I feel relevant questions about this report that you have prepared. And only if you know the answers, you can volunteer them. If you do not know, then I would suggest that you say so, that you don't know. So to begin with, this report is prepared in a laboratory. Do I take that to be correct?
Yes.
And when this, so in your laboratory or in your forensic science lab, which is obviously a bigger institution, there would be various departments. Is that correct?
Yes.
One of such departments is the laboratory where all these tests are carried out. Correct?
Yes, sir.
Now, there would be a department where these samples that we see in the test, we see some samples in the test. Correct? So those samples that we see in the test and in the report, those samples are received by some other department apart from the laboratory department. Is that correct?
Yes, sir.
What do you call that department in your FSL laboratory?
The receiving department.
The receiving department. Okay. So the sample which comes from the police, I'm putting it in very simple terms. I really don't understand your technical scientific language. So I'm going to speak in very, very simple terms. So when the sample comes to your receiving department, from the time it reaches your receiving department to the time it reaches or comes to your receiving department to the time it reaches your laboratory, you don't know what happens to that sample.
Yes.
Okay. So in this case, the samples that you see, now I'm asking you particularly about this case. This case, the samples that you see must have been or could have been received by your receiving department.
Yes.
Correct. Now, in what condition they were received by your receiving department, you are not aware today.
No, sir.
Okay. Now, you also don't know what is the time lapse between the time that these samples are received by your receiving department till the point of time that it reached your hands.
So we have documentation for receiving. So they have a log in which they would enter the date and time when they received the samples, the state of the samples, and
Correct.
what they did with the samples, how they stored the samples.
Right.
Thereafter, when they come to me, I would also document similarly the state in which I have received them, the date and time that I have received them.
Wonderful. So these doctors, all this documentation is carried out by both the departments. That is your department, that is the lab department, as well as the receiving department.
Yes, sir.
Yeah. But along with your report today, madam, you are not carrying your department documentation at least.
No, sir.
Okay. So in your, I'm just making this a little more magnified so that I can read it. So in your very first line, you say details of the parcel and exhibit received. Then there's a chart. You say parcel number 1 is exhibit 1. It says culture tube containing 2 ml of reddish fluid said to be blood. Okay, I'm pausing here for a minute. Now, when you say, or when you have, first of all, let me ask you this. Have you yourself mentioned this comment? Or one of your assistant or junior has done it?
I myself have done it, sir.
Okay. So when you say that the reddish fluid is said to be blood, do I take it that at that point of time when you made this entry, you were not sure as to whether that culture tube contained blood, that is human blood, or not?
No, sir, that is incorrect.
Why is it incorrect, madam?
So the normal procedure for any biological sample like blood is that it will go to the serology department. The serology department is in charge of examining the sample, which is reddish fluid, and establishing that it is a blood sample. After they have completed establishing it as a blood sample, they will send it to me for DNA analysis.
Correct. So now we come to another department of yours. Just as you have a receiving department and a lab department, you have a serology department.
Yes.
What you just said is that the serology department does the blood grouping and finds out whether it is human blood or not.
Yes, sir.
So I take it that at the time when you made that entry, the serology department had not done any of this grouping, which is why this entry is written.
No, sir.
Why do you say no?
Because I have been informed that it is blood, which is why I am stating that it is said to be blood.
Okay. So this information was oral or written, madam?
Written.
Okay. And you are not carrying that written information today?
No, sir, it does not pertain to my department or my report.
Very well. Okay. We move ahead. Now, you have in your methods, I'm just reading out from what you have written. You've written DNA from the above exhibit was isolated by FTA purification method and subjected to multiplex PCR reaction for 15 STR loci and amylogenin using AMP-F/STR identifier plus kit. Now we'll pause here where you're talking about the kit. So what is this kit? Can you explain to the court what this whole kit is about?
Yes, Rajesh, I heard you. This is a standard commercially available testing kit that is used in laboratories to identify these 15 STR loci and the gender locus amylogenin. It is commercially available and bought by the laboratory, and this is what we use as standard operating procedure.
Okay. So you just enlightened us when you said that there are different departments in your institution. We spoke about your serology department, we spoke about receiving department, and where you are yourself working, that is the laboratory department. Now, none of these departments, or rather your department, the laboratory department, has nothing to do with the procuring or purchase of this identifier plus kit. Is that correct?
So we put in our purchase orders and the administrative team takes care of it.
Correct. So I'll rephrase my question again. You would not know from whom and at what cost this identifier plus kit is brought.
So I would know from whom it is come because it's on the label of the packaging, but at the cost I may not know.
Fine. Now you have acquired that kit. Now tell me something. Now when you conduct this case, or when you conduct this test rather, is it that you have to open a new kit every time, or previous kit is good enough for the next test also?
So the kit can accommodate a number of tests simultaneously. So a number of cases would be examined together.
Okay, so you don't need to open a new kit every time you test. Is that correct?
Yes.
Now, since you said that you are aware as to when these purchases and from whom these purchases are made, you would also be able to tell the court that do these kits come with an expiry date?
Yes, sir.
Okay. So obviously, as a prudent scientist carrying out these tests, you would see to it whether, or rather you would check the expiry date of your kit and then only use it. Is it not?
Yes, sir.
Okay. Now, in this particular case, have you checked the expiry date of that kit?
Yes, sir.
Okay. I don't find it written anywhere in your report that you have checked the expiry date of the kit. Can you give any reason why you have not done so?
So it is not our practice to document it in our reports.
Okay. So do I take it, madam, that apart from your bare words that you checked the expiry of the kit, there is nothing today on record to suggest that you did so?
Yes, sir.
Okay. Now, this kit itself comes from an external source to the laboratory. Is that correct?
Yes, sir.
So what checks and balances do you have to ensure that this kit itself is not contaminated and the kit is intact?
The kit is normally sealed, so we break open the seal and we document breaking open the seal.
Or such
The
documentation.
seals are not, they would be in my lab notes.
I'm so sorry. Can you just repeat that answer for me, please?
The packets are usually sealed. The kits are usually sealed kits. So whenever we open the kit, we would check whether it has been contaminated in terms of breaking of the seals, whether it has already been opened or torn, the packaging is damaged. Otherwise, if it is intact, then we would go ahead and use the kit, provided the expiration date had not passed.
Okay. So I take it that you found that this kit was intact and therefore you went ahead and did the test.
Yes.
And you also said that you normally document these things. Where do you document those things, madam?
In the lab notes.
Which you haven't carried with you today?
No, sir.
Okay. Now we turn to your next paragraph. The amplified products along with controls were run on automated sequencer and analysis was carried out using gene mapper software with respect to standard ladder. Okay, so again, these things we don't understand because we are not familiar with the technical terminology. But one thing catches my attention, which is a software. So do I take it, madam, that this is a software like any other computer software?
Yes, so it's specifically designed to interpret the DNA results, capture and interpret the DNA results.
Okay. Now, if it's a software, again, you have to pardon my ignorance. If it's a software, then it would be manufactured by some software company.
Yes.
Correct.
Yes.
And also, many of these softwares come with their encryption keys and the fact that these were purchased authentically, that is also certified. So would you happen to know anything about the gene mapper software used by your laboratory and whether it was authentically purchased and whether it contained these encryption keys, etc.?
Yes, sir. It's a Thermo Fisher scientific company that produces the software kits, which we purchase periodically when we get a new instrument.
Okay. Now, what is the, do I take it that when you use this software, you are responsible for any flaw of the software? If there is a flaw, would you be responsible for the flaw or would anybody else be responsible for the flaw?
I'm unable to answer this question.
Okay, I'll rephrase it again. Do I take it that this software is used by you in all the tests which are connected with DNA analysis?
Yes.
Okay. Do you personally use this software?
Yes.
Or you delegate this duty to somebody else?
No, I have personally used this software.
Okay. Now, when you use the software, is there any security controls that you undertake before you use this software?
Yes, sir.
Can you describe them for us?
The login and password.
Okay, fine. I am very happy that you said that there is a login and password, because that brings me to my next question is who shares this login and password?
The department head.
Okay. So do I take it that apart from Riva Pocha, that is you, there would be other people in your department who would be having this login ID and password?
Yes, those who are using the instrument.
Okay. So it is possible that several people are using this gene mapper software in a given day. Several scientists are using it for different tests that they carry out.
Yes, so.
Thank you so much. Okay, now all this gene mapper software and how it is used, What are the checks and balances? What is the software integrity? Do you have any documentation that is there uh, on the basis of which you use the software?
So there are training manuals.
So if I read correctly, you have written as per working procedure manual RFSL DNA OPM.
Yes.
Now, do I take it that you have got this working procedure manual today to court?
No, sir.
Okay, you haven't got this. Fine. So we move ahead, madam. We come to your next page, which is,
Ashish sir, can I just add commentary here, please?
yes, please, please.
I am not sure about this password. So this is not real. Okay, I've answered you, but I'm not sure about this process. So I would rather make sure that everybody is aware that I just answered questions.
Okay, so now
But
I'll
it may
also
not be
add you.
factually incorrect. It may not be factually correct.
See, the effort of this exercise is not to demonstrate factual aspects. So if, let us say, there is a software, a defense lawyer is going to ask whether the software has a login or a password. Okay, now depending on the answer, so there is no golden answer. In a forensic science laboratory, a particular laboratory, there may be a login password. In another one, there may not be a login password. In some, there might be gene mapper software sourced from a particular company. In others, it might be from B particular company. So these answers are not some, some magic wand, or these questions are also not magic wand. I am looking at the report in front of me and I am thinking up these answers. Madam is thinking like a forensic science laboratory expert, FSL expert, and she is giving these answers. Neither of them are any kind of a sacrosanct parameter that you can use these answers and this you can ask these questions and this will be the answer. So I hope the exercise, the relevance of this exercise is very clear. This is not some kind of a gospel truth that we are telling here. We are just giving you an idea on how to cross-examine this witness. Okay, so moving ahead, we see these parcel and exhibit received. So we have two parcels which have blood, culture tube containing 2 ml of reddish fluid said to be blood, glass bottle containing. So can you just tell us, because this again is Greek and Latin for somebody who's non-technical like me, what are these parcels and what does this exhibit 2, 31, 32, 33 all about?
All three parcels are biological material. Exhibit 1 on the earlier page was blood that was drawn from the accused father, supposed father of the
Pause here
child,
for
the putative father.
Okay, so this is the one that you're talking about, madam? Exhibit
Yes.
1. Yes.
Exhibit 1 is blood that has been drawn and put in a culture tube and has been drawn from the putative father.
What do you mean by putative father?
The so-called accused,
Okay,
who
fine.
we suspect to be the father.
Okay. Now, what is this 2, 31, 32, and 33?
Exhibit 2 is similarly a known blood sample that has been drawn from the mother of the child and has been packaged and labeled Exhibit 2. And Exhibit 3 is 3 parcels packaged together, all pertaining to the child. One is a sample of the blood from the child itself. The second is a sample of the placenta, and the third of the umbilical cord. These samples were taken at birth of the child and should all be consistent with the same DNA as the child because they all come from the child.
Okay.
So they are to establish that this is not another child that was put into the mix from another birth. It's from this birth with this placenta and this umbilical cord.
Fair enough. Now we move to your next page, which tells us about the results of the analysis. Now we see several columns and rows here. One is the STR marker identifier. Then there is a control DNA. Then there is exhibit 2, which we just explained. Exhibit 3, that is the blood of the child. exhibit to then the exhibit 1, that is the blood of the father, correct?
Yes.
Now, numbers, you see a lot of numbers there, 16.6, 13.6, 30.32.2. So all these numbers are there. Now, as I understand, and you will correct me if I'm going wrong, as I understand, your gene mapper software
Yes.
gives you data or output in the form of graphs and not numbers. Is that correct?
Yes.
Okay. So, it is by a process of analyzing and interpreting these graphs that you arrive at these numbers. Is that correct?
Yes, sir. Gene Mapper software will identify all the peaks and will make a table of all the peaks. And it is after that that we will examine, interpret what the Gene Mapper software table has generated and prepare this table.
Okay. So I take it that this process of interpretation and analysis is a manual process. It is not an automated process.
From Gene Mapper table to this table, yes, it's manual, sir.
Yes. And it is done personally by you.
Yes, sir.
Okay. So typically, it is possible that while you are interpreting and analyzing this data, there can be either an inadvertent error by you or there might be a clerical error. I'm not saying that it is deliberate. I'm saying it could be inadvertent by mistake, or it's a clerical error which you have simply oversight. Is it possible, madam? I'm not asking about this case. I'm asking generally.
Yes, sir.
Okay. So technically, because it's a manual process, you are saying that there is a possibility of an inadvertent or a clerical error. Is it also possible that as a scientist, you can give one particular interpretation to that graph that comes out of your gene mapper software, and maybe another scientist can give another interpretative analysis of that? Is it possible?
I am unable to answer this question.
Okay, let me probe it from a different angle. Is only one, so are these graphs that come out of the software possible of only one interpretation?
Yes, sir.
Okay. And you have made that interpretation. That is what you are saying in this report.
Yes, sir.
There can be no variation in the interpretation.
No, sir.
Okay. Now, in a given day in your institution, how many graphs do you interpret?
Between 5 to 10, sir.
Okay. Because you carry out so many interpretations in a day, is it possible that there might be a human error in any one of your interpretations?
No, sir.
Okay, so you are a superwoman. I must hand it over to you. Wow. Okay, fine. Now, this table that I see has so many numerals. Now, the accuracy of the numerals, these numbers, would depend on the accuracy of your interpretation. That's correct?
Yes, sir.
So if your interpretation is wrong, either because of clerical error or because of inadvertent error or because of any other reason, then your chart would go wrong. Is that correct?
Yes, sir.
Okay. Now, is there anything more? Okay.
Yeah.
These are your findings. From the above results, it is observed that one of the allele of the DNA profile, etc., source of X2. From the above observations, it is concluded STR profiles. Okay. Now, madam, there is one general question that I would like to ask you about your report. All the 3 pages or 4 pages that we have seen. When you make these or when you carry out these tests, do you make any contemporaneous notes that I have done this at so and so time, then I have done this at so and so time? Do you make any contemporaneous notes?
Yes, sir. Those are the lab notes.
Okay. And you haven't carried those live notes today?
No, sir.
Okay, fine. So now this is again a commentary. I have come to the end of what we call as a cross-examination. Now I will ask the witness what we call as the suggestions. Now, why are we asking suggestions? First, we understand that, and then you will understand what are the questions or what is the relevance of the question. You look at the entire case or the entire trial as a kind of a narrative and a counter narrative. The narrative is what the prosecution is trying to prove beyond a reasonable doubt. Now, let us not go into onus, beyond reasonable doubt, preponderance of probability. Forget all these jargon. The narrative that the prosecution wants to establish is that the prosecution is going to prove its case. And the counter narrative that you want to establish is that there is room for doubt, which you want to create in the mind of the court. And that doubt will then give birth to a possibility of an acquittal. Now, in this interplay, so a trial is actually the interplay between these two narratives. What a defense lawyer does and what he should do, I will tell you both things. Normally, a defense lawyer stops here. Okay, he stops with the cross-examination. Let us take for a minute that this cross-examination is brilliant. I have got a lot of admissions from the witness, which I can use to show that there is an element of doubt, that there are some gray areas, that there are some discrepancies, that this so-called test is not foolproof, that there are possibilities of errors. Now, I have done all of that. But unless I give it a grand finale, unless there are some conclusions that I ask to the witness, I cannot make a point before the court that either this witness is not telling the truth, or the processes by which this witness has conducted these tests were not scientific, or there were so many inaccuracies in her observations that ultimately the report is not something which can be relied upon. These arguments I can make only when I put my suggestions to the court or to the witness. So this is the relevance of the suggestions. Now, in that light, understand the suggestions that I am asking this witness. Okay, madam. So we come back to the closing part of my cross-examination. So, madam, I'm really thankful that you have spared your valuable time and answered these questions. So I'm going to ask you questions which would be in the nature of suggestions, and you're free to say yes or no to my suggestions. Okay?
Yes, sir.
The first question that I would ask you is, it is my case to you, I am suggesting to you that the processes by which you have conducted these tests are neither scientific, or rather, they are non-scientific and arbitrary.
No.
Okay. So what am I trying to drive at from this question? I am trying to show, or rather it is going to be my case, when I finally marshal my final arguments, I will say that the processes are, one, not scientific, and two, they are not in a proper manner. So therefore they are arbitrary. Okay, the second suggestion. There are various discrepancies. That's my suggestion to you. There are various discrepancies and inaccuracies in your observations, which have ultimately led to faulty findings.
No.
Okay. I put it to you, madam, that you have not carried out a proper chain of custody, because of which the samples could have either been mixed up or cross-contaminated.
No.
I put it to you, madam, that therefore, in the light of all these questions that I have asked you, your opinion is not a valid opinion in the eyes of law, and it does not have any relevance.
No.
So that is where I close my cross-examination. Now you will understand why I have asked those questions, because I want to raise the foundation of my defense case, the counter narrative that I am going to tell before the court. Okay. So Yeah, it's 8:15. We will now discuss about one more
Can I
report.
just stop for 2 seconds? Since we've done the theory, I just feel that I should also explain this report
Wonderful.
because
Okay, so now we are out of that rules
2
and
minutes.
back to being what we were.
Yeah.
Okay, so
So
I'll
I
stop.
just want to explain the results.
So do you want me to screen share or do you want me to stop or what?
You can screen share, sir, then we'll switch to my screen when we do the second case.
Okay, fine. So what do you want me
This
to?
exactly that opinion page. I just want to explain the opinion because there's terminology there that may not be familiar. So I just thought I would explain it. So the first statement says one of the alleles of the DNA profile of the blood sample said to be of the child, source is exhibit 3.1, which was the blood, matches with one of the respective alleles of the DNA profile of blood sample of exhibit 2, which is the mother. So what it is saying here is that the child, one of the alleles matches with the mother. For all the loci, for all 15 loci that were examined, based on that DNA chart, they're able to interpret that one allele matches with the mother. The second statement is non-maternal alleles of DNA profile of the blood sample of the child, again, source exhibit 3.1, are present in the DNA profile of the blood sample of exhibit 1, which is the father. So basically, this means non-maternal alleles means that whatever alleles that were not coming down from the mother's side, so not on that X chromosome, on the Y chromosome, those showed similarity or identity with the DNA profile of the putative father or the suspected father. So there was definitely inheritance between father to child. So this man is in fact the father of the child. So from the above observations, it is concluded that the STI profiles of the suspected father blood sample is consistent as the biological father of the child whose blood sample is exhibit 3.1, who is the child of so-and-so mother, blood sample exhibit 2. So now the paternity and in fact the parents, both parents have been confirmed as the parents of the child.
So do I stop screen sharing now?
Yes, so that's all I wanted to explain.
Yeah. So I think now you can take over from there and talk about the other report that you wanted to discuss about.
Sure. I actually, what we're moving on to for those who are, sorry, I just want to.
Raghav, can you excuse me for a second? Somebody's on the door. I'll just come back in 2 minutes.
Sure.
I just need 1 second to pull up that.
Ma'am, before the report that we are taking now, should we be taking up questions that people have?
Yes, maybe that makes sense because this is something different. The next case, I'm just showing you a report of a POXO matter. And in that POXO matter, it's not about paternity. It is about whether the evidences from the victim match the DNA of the accused. And I'm just talking about those reports so that we have completion since today is the last day.
Right. So I hope abhi tak whatever we did, it was understood by everyone. And the objective also that we wanted you to understand how far can you go when you're in front of an expert and you're examining an expert, and how can you use these reports. So that was the objective. Now on that, if you have developed any questions, then we'll take those up. We have Ayushi first, going first.
Hello, my questions are for Ashish sir.
Yes.
He's not actually he's back. Sir, is it advisable to call for the lab notes?
Under what provision of law will you call for it in the first place?
Riva ma'am was telling us the other day that you should call for the lab
You
notes.
can. I know that you can because I've seen experts bring in their lab notes.
No, I am asking you a very simple, straightforward legal question.
Under the provision of law.
what provision of law can you call for it? If Riva madam is, gracious enough to carry the lab notes with her, and I can ask her, yes, you're carrying your lab notes, please show it to me. I'm just playing the devil's advocate. I want you to answer, if at all these lab notes have to be called for, under what provision of law will you call them?
So the last section of the Evidence Act, where the judge can call for anything like in the interest of justice. 1 second, I just see the section. I think it's 145.
165.
165, sorry.
Correct. So
Yeah.
you will make an application to the judge that in the interest of justice, the
Yeah.
lab should be called for. Should be called for.
Yes, sir.
Any other provision?
Sir, we may also use maybe, I'm not sure, like can we use the 66 and 163 and 164?
66 won't be the right remedy because you don't have the originals. No? 66 comes into picture when there is a situation where the originals are not in your hand, and if so you have got the photocopies and the originals are with somebody else.
Right. So we can we use 163 and 164?
Why not try 91?
So 91 again would be, applying to the court or to the police.
No, so in this case the court.
Yeah, so वो तो 165 में भी हम कर ही लेंगे.
Correct. So basically, what you are trying to say is that the lab notes can be called for from the court. Now, it's a arguable question under what provision of law? Correct, Ayushi? Okay. So now my counter question to you is, what is the purpose of bringing the lab notes as a defense lawyer? Let us say that these lab notes are called for, they come. Now what?
It might weaken my case. Therefore, I was asking you.
Therefore, I'm answering your question. So now I'm putting on the hat of a defense lawyer. You are asking for material which you are not very sure is going to help you. And the cardinal rule of defense is that don't ask a question whose answer you don't know. I think that makes it very clear.
And sir, we have asked several questions, and I wanted to know which of these actually has impeached the credibility of an expert witness. कोई judgments है कि जहाँ पे सच्ची में she did not bring the lab notes, or she is not aware that the chain of custody was properly maintained, or the software is not credible, has actually impeached the credibility and created a reasonable doubt in the mind of the judge.
Okay, so I would like to answer this in a little different light. You can't pinpoint a single question. So this is like a jigsaw puzzle where you are looking at the report and the person authoring the report and trying to find out whether the person who has authored that report has done this whole system in a manner which is expected of that person, to put it very simply. Okay, so now going back to what I asked. First of all, it was the condition of the parcel, how it was received, receiving department, dichotomy between the receiving department and the laboratory. The laboratory doesn't know how, in what manner these samples are received by the receiving department, how they travel, how the chain of custody is maintained. Now, this obviously the receiving department is not going to examine its own witness. So the purpose of this line of questions was to create some doubt in the mind of the judge as to what is the sanctity of the sample during its travel from the FSL to the forensic scientist. Okay, that was the main idea. Now, once it reaches the forensic scientist, assuming she makes the proper tests, everything, but if the sample is either cross-contaminated or it is mixed up and there is nothing to authenticate it otherwise, then that could create a doubt in the mind of the judge as to whether all the procedures have been correctly followed or not. Then the next line of question was about the kit, whether it is needs to be opened up every time, whether it is, what is the expiry date. So I was trying to find out the knowledge of the personal knowledge of the witness about the instrumentation. See, a kit is basically nothing but the instrumentation. Tomorrow that instrumentation could be different. It could be some lab equipment, it could be anything else. So that is one area that the defense lawyer can focus on, the instrumentation and the viability of that instrument, the knowledge of that witness about that instrument. Now, in this case, whether it was expired or not, whether it is contaminated or not, intact, etc., etc. Then, since there was a software, I tried to capitalize on the software part of it. See, all these clues come from where? They come from the report itself. Had the report not mentioned about GeneMapper software, I wouldn't have been aware about GeneMapper software. I wouldn't have made any efforts to find out anything about GeneMapper software. And I wouldn't have obviously asked any questions about GeneMapper software. Because so basically, these clues will be provided to you in the report itself. So you have to microscopically look at this report and then try to find out the weak links. Now, what I mean by weak links is this, that an expert is an expert in his or her own field, but you have to find out those aspects which the expert is not an expert on. Now, you could take a chance and ask, I mean, it's worthwhile to take a chance and ask whether the expert is aware about the software. It could be anything. It could be even the agreement entered into, I think somebody has mentioned that also, agreement entered into with the company which has purchased the software. Answer would be no. Obviously, the witness wouldn't know anything about that. So what we are doing here is, the questions could be manifold. There is no end to the questions that you can ask. This was just an illustrative example. This cross-examination technically could have gone on for 1 hour, 2 hours also if I wanted to drag it that long. The idea was to give an insight into what are the various things that one must look at. So one was the instrumentation part. Now we found a software, so we tried to probe into the software. Why I am doing all these things is, instrumentation is not the forte of the scientist. Software is not the forte of the scientist. Chain of custody is not the forte of the scientist. And also the fact that various hands are participating in this process. I'm using a figurative explanation. So various hands means could be a receiving department. Then we had this interesting discussion about serology department. What does the report say? That reddish fluid looks like blood. Now, looks like is a word which caught my attention. Looks like is a word which caught my attention, because that means that you are not sure whether it is blood or not. Then we got the explanation that there is a serology department which sends these reports. So serology department conducts the grouping. It finds out that it is a human blood and it sends the report. But what I succeeded in finding out, or rather showing, is that there is nothing except the oral words of the scientist. That I was informed. Ultimately, this is what we get. What the scientist tells us is that I was informed that this is human blood. Now, there is no corroborative material to show that there was such information given. Now, it could be possible.
So, can I just point out something? I'm sorry to interrupt,
Yeah.
but it's interesting that this case is a Gujarat case, but in a Maharashtra case, you will see that at the bottom of the serology report, they will write that the samples have been forwarded for DNA identification.
Correct. So therefore,
there is that chain of custody maintained because of that single line of documentation, but I did not see it in the Gujarat reports.
Excellent. So therefore, these are the again, as I said, this is no magic bullet. You can't kill Satan with one magic bullet. So so there is no magic bullet here. We have to all put our heads together and find out the various things that can be looked into. So as you correctly said that there might be in some cases there might be a report. So to give a summative answer to your question, Ayushi, there is not a single question that has turned the complexion of this case. And don't expect that in any of your cross-examination. That eureka moment doesn't come where the witness falls apart. That happens in movies. The witness doesn't fall apart. You have to slowly remove one brick, one stone, one something, slowly work on that witness and try to show that there is some doubt in what the witness is showing. To be able to show that the witness is an absolute liar is an ideal situation. Never hope for the ideal situation. In practical life, it never happens, or very less likely to happen, that you will demonstrate that the witness is a liar. Most ideal situation, I agree. But in real life, what can be done is an attempt can be made to slowly and steadily show that there are some doubts that the judge can entertain about the processes used by the witness. And those doubts can then be slowly magnified, and an attempt can be made to show that there is a possibility that this could have gone wrong, completely wrong. And once that possibility goes from the realm of probability to possibility, पहले तो probability है, then there is possibility. Once you show that there is a possibility and a real possibility in this case, then you have got the judge's attention. So it's like looking at a jigsaw puzzle. Any other questions?
And sir, how much how much do you think we have succeeded in putting up this cross-examination and the kind of answers that ma'am has given? How much would this kind of cross affect a case like this?
Again, I'll have to answer this holistically. So if you have a case where 80% of it is in your favor and 20% is against you, and you have got these answers, then I will say that now you have 90% in your favor. But if you have a bad case, where the case is anyway heading for conviction, there are eyewitness evidence, there is circumstantial evidence, and always remember that expert witness is an additive evidence. It is a corroborative material. It's very rare that you will find that only on the basis of expert witnesses people have been convicted. You will find that line in many Supreme Court judgments. But when you read that judgment, you will find that there are other materials which ultimately add up to what the expert says. So to answer your question, if you have a good case, this is going to get better. But if you have a bad case, don't hope that because of whatever little you have managed to gather in this cross-examination, you could get an acquittal.
Right. And sir, as a prosecutor, was it me that who could not point out any point of objection, or was there no place that I could object to?
No, you could have objected to some things, but yes. So yes, you.
I think the software, right? I mean, the probing of the software and the purchase department.
Correct. So when I was going on something, so basically the line that you have to understand is, I can ask questions as a defense lawyer, anything under the earth. That's no problem. But it has to confine, or I have to confine myself to the knowledge of the witness on this particular report. Okay, so the moment I try to go to the software, I enter into, maybe I'll ask about the agreement. Let us say, for example, I ask this question: that are you aware that your institute has any agreement with a software producer, a manufacturer, and you source these from a particular manufacturer? You could obviously get up and say this question is not relevant. How would this witness, who is talking about a report which is authored by her, would anyway have any knowledge about this? So there could have been, I'm not saying that these questions are right or wrong. I'm saying, I'm answering your point as to where you could have intervened. What the judge finally decides, maybe in a particular case, it will say objection overruled. In a particular case, they will say the objection is sustained. वो बात की बात है. But where you could have taken objections, I am trying to show.
Right, sir. And sir, also, जैसे आपने मुझे बोला कि I could not ask those leading questions. What if I ask and no one objects?
Many a time that happens.
So like I am asking that because I've actually done it, and now I just thought कि मैंने वो कर तो दिया है, but if that has been recorded and it is a leading question, then can it afterwards affect my case, like in vitiating it or something like that? Is it something?
No, that is not likely to happen, because fortunately we don't have, unless of course I stand corrected if in your state there is a question and answer form. But normally in the state from where I normally practice, we don't have a narrate, we have a narrative. So only the answers are taken. It is correct to say blah, blah, blah. Or the answer that Riva madam gives, only that goes on record. The question normally doesn't go on record unless there is a contentious issue and the judge says, all right, no, if there is a fight between the prosecutor and the defense lawyer, and the defense lawyer says, no, this is what I wanted to ask and this is the answer, and there is some kind of controversy, then the judge says, all right, what was your question? This was your question. And what is the answer? This is the answer. Normally, that narrative, the question answer form is normally not used. So you would be safe because nobody would know whether you have asked a leading question or not. But in some states, they do have that question and answer form. In that case, somebody might say, oh, these leading questions are asked. But understand one thing, after the whole thing is gone and done, and there is a result, or there is a conviction or acquittal, nobody can go and vitiate this trial because leading questions were asked, because the focal point of determining whether there is a mistrial or whether there is something which is called as a miscarriage of justice is to show prejudice caused to the accused, not merely mistakes. Mistakes can happen, errors can happen, but whether those errors were fatal to an extent where there is grave prejudice caused to the accused. Only in that extreme circumstances the trial is set aside. Otherwise, these errors, if nobody points them out.
So we use 362 and 167, all that.
Yes.
Right. Got it.
Follow-up question that you had.
Ayushi had a question.
Yes, sir. Riva ma'am last time had cautioned us to not go into or not indulge in a too technical cross-examination. But since I know that there is a certain quantity of DNA that needs to be collected and amplified, can I question her on that? Like, how do you know that since you have received this sample from some other department, how do you know that this amount of blood is sufficient to get to give a perfect result? Or how do you come to know that
Hold on. I'll just pause you for a minute. Ask that question again and let Riva ma'am answer it.
I've understood the question she's asked,
Okay,
and I'm going to answer it. And my answer is standard operating procedure.
Okay, ma'am.
I have measures that quantify the DNA.
One second, I'll just answer the door. Hold on for a second.
So as an expert, I would not go into the detail of how I did this. I would just say standard operating procedure, and the working manual has been quoted in my report, and that outlines all these processes or steps. So it would become a block for you. You can't go beyond that.
Hello, Ashish.
Yeah, he's just come.
Yeah.
Oh, I'll ask a follow-up question, ma'am. Still, can
I didn't follow. क्या हुआ end में?
Ma'am ने कहा standard operating procedure is there, and I have followed it.
Okay, so can you not ask what is the standard operating?
Ma'am, I was going to ask, ma'am, I am a non-technical person. Could you please enlighten me what is the standard operating procedure and how much quantity has to be taken?
Let us assume that she tells you the standard operating procedure. Then what?
So on the paper, in this particular report, have you made a noting as to whether you had taken the appropriate quantity?
Going back to documentation, right?
Yes.
No, and I've also answered this because I've put over there the working manual quote. I've put that bracket is said very clearly in methodology that I've followed the lab's working manual SOP.
Okay.
And ma'am, one more question from the graph that has been given to you by the gene mapper. How can you gather that there was no noise in the graph, or it didn't take into account the stutters,
exactly.
dropouts? Yeah, dropouts.
That is where he said, that is exactly what he probed. When he asked me if another expert could interpret it differently, he cornered me because I had to say yes. Technically, I had to say yes, because what you actually could have explored there is the probability of errors. The wording would have been probability of error in interpretation. You could have probed that a little bit.
I was fortunate not to be your student, so I wouldn't know what a stutter is, but Ayushi knows, so she's smarter than me.
So there are those tiny little peaks next to the big peak.
I know.
And
Now
sometimes if you have very poor quality DNA or you have disintegrating DNA, then even though you're getting a profile with those peaks, the peaks are so small that they're the same. They look like noise peaks, like I taught them. And so then it's really up to the expertise of the DNA expert to interpret whether this is actually an allelic peak or it is a stutter. And the students should understand those words now. So the focus could be basically on probability of errors in interpretation, because how many of these reports have you interpreted in your life that you can be confident of making that distinction? So you would force the expert to talk about the quality of the sample that came to them. And they would talk about the fact that maybe this was, say, for example, it's a decomposed body and the DNA sample is compromised because it's a decomposed body or it's a burnt body. But then you're taking it into a line of questioning that you need to have knowledge to continue.
exactly. So that is, I think that is the success of this program.
So I could have asked her that कि मैडम आपने कैसे डिस्टिंग्विश किया नॉइस को स्टटर्स को एलिलिक
हाँ, exactly. So ये तो मैं पूछ ही नहीं सकता था ना, मुझे पता ही नहीं आयुषी. So see, that is the difference between you and me now.
सर आप मुझे चढ़ा रहे हो. Okay,
just to also share that today, I don't know, Raghav, if you had a chance to share that primer, but I had completely forgotten I have this, and I think it'll be extremely valuable to every single student. There is a primer that has been created in the British courts for the British court, which is a DNA primer. So it's a document that is about 50 pages long that explains DNA for a courtroom beginning to end. And I feel like after this program, it'll be much easier reading for you because all the words are familiar, concepts are familiar, and you'll really be able to internalize and in some way become an expert in DNA cross if you've read that. So I've shared that document. It's a PDF document, and please, please, please go through it. If you have any questions, you can contact me through Raghav. No problem.
Right, ma'am. I've shared the document with everyone. So I guess we'll catch hold of you when people have questions. And
so now we are moving to the last part of the program, if I'm not wrong.
Yes, sir.
Yeah. Okay. So
Yes, okay.
with everybody's permission, can I exit?
Or so now I will be done in 10 minutes. Can you stay in case they have questions?
Give me some time. I'm not in earshot right now. You can continue. I'll join you in 5 minutes.
Sure.
Okay.
So the case that I'm now sharing is another case. This is a case of, again, rape of a 9-year-old. So under POCSO.
Can we zoom in?
Ma'am, you've raised your hand.
Hello.
Yeah.
Hello.
Yeah.
Am I audible?
Yes.
Yeah. I have a one like as I know that today is the last concluding session. I requested earlier also that will we get a compiled session, entire session compiled all together, so it will be very easy for us to go through in a one go.
Yeah, we're doing that.
Okay,
as of today, the whole thing is complete and the reference material, everything will be given to Raghav to share.
Okay. Thank you, ma'am. Thank you.
Okay, so this is a case in which the accused was finally picked up, and the child, 9-year-old, obviously she died in the incident. And what I've done is I've just put some of the reports together because it kind of demonstrates exactly what we've been talking about in theory, and also allows me an opportunity to explain to you the wording in the reports in case that you may not actually be doing POCSO cases and seeing these reports on a day-to-day basis. So this is just how the samples have been sent in. This is the jeans pant wrapped in paper labeled XYZ, the full shirt wrapped in paper labeled XYZ. So this has been sent to FSL for examination. These are the clothes of the accused, and they have been obviously sent after they were collected post-medical examination in the hospital. Now, the results of the analysis is what I wanted to show you, because if we just refer back to the earlier case where I said the serology department gets the clothes first or gets the evidence first, here again, this is clear. The serology department has taken the clothes and they have examined the pant and they found a blood stain on the middle portion and in the inner pockets. But on the shirt, there was no blood, which was exhibit 2. They have found no semen on exhibit 1 and 2. And then they have gone on to do a species of origin, which was that whole concept we talked about of establishing that if it is blood or semen, then is it human or animal? And so here, this is the species where they're saying very clearly that exhibit 1 had the stain, which was blood. It was human blood, but they were unable to group it. And then that is the end of the serology. So that's what the report would look like. And if you see, again, I was explaining this in the earlier conversation with Ashish sir, analytical report regarding DNA examination of exhibit 1 from DNA division, read so-and-so is attached here with. So this is that preceding document that shows that it is connected to the DNA report and it pre-existed before the DNA analysis was done. Then I just wanted to show you one more report from the same case. And here the DNA has been extracted from the blood that was detected on the genes. So this is a continuation of that same blood sample where they could not do the ABO grouping, but they were able to say that it is human blood. So when they didn't do the ABO grouping, they moved it forward to the DNA lab, and the DNA lab went ahead and did DNA profiling using 17 YSTR loci. So this is slightly different to what we've been talking about all along, because we've been talking about 15. So this is a slightly superior profile. Also notice the YSTR means that they're looking at the male fraction. That is why they're particularly choosing the YSTR loci. And then the rest of it is the same. It's the same kit. It's just that this is the name of the kit. So the kits differ. It's all AMP-F, STR, Y. But here, if you see, that was identifiler when it was doing the paternity case. Here it is Y filer. So same manufacturer, same concept, but inside the chemicals are slightly different because we're going for YSTR and 17 loci, and that was 15 loci and amelogenin, where we were saying it can be X or Y. Amelogenin was for sex. Then you look at the report, we all understand the profiles of the loci now. These are the names of the 17 loci. And if you look at the external genes full pant, this was genotype. At this point, I would say just ignore. So genotype and phenotype. Phenotype is what is physically expressed. You are aware that there are 2 alleles always. And when we were looking at what alleles were, somewhere I had shown you an AA, a BB, and a CC. So if you looked at that, that was the genotype. That means what is actually genetically present inside the blood or the body fluid or the DNA. But sometimes, not sometimes, always, there is something known as dominance, which is why if my mother has black hair and my father has brown hair, it is possible that I will come out with black hair because black is dominant to brown. And so if, very simply, if the big B was black and the small b was brown, I would show black hair, but it would be different internally. I would have a mixture of the two. So we can maybe, for this particular, since we're wrapping up, I don't want to get too much into this, but you may want to understand why there are only one profile showing up over here. Okay. And the reason for one is because it's YSTR. There's only one Y chromosome. So it's one Y. Okay. And then it says male haplotypes of blood detected on the gene pant, which means that we're saying very clearly that the DNA on the gene pants was of male blood. And then if we look at the male blood and compare it to the accused, the profiles are matching. So that is basically what it's saying, from the same paternal progeny, because the Y chromosome is the same in both samples. So the loci that we're looking at on the Y is the same for both. So we can say that it came from the same male source. The paternal side is the Y chromosome. Raghav, you have a question?
Yeah, ma'am, I wanted to ask, why is that one of the A's or one of the B's is dominant on the other one?
That is, oh, that's a very interesting, very basic question. I don't know the answer to it. It's gene expression. I am.
Why would one express, dominantly?
I don't know how to answer that.
Like even superficially, what is the logic behind it, if there's any?
The logic is basically that one is structurally, maybe structurally inferior to the other,
Okay.
if you want to think of it like that. And so this one gets, it's like a selection of the fittest.
Okay, so in that the example that you gave, the gene type of the mother would be a structurally stronger one than the father's.
If
In
the
that
black
case.
was the mother's hair, yeah. And
Yeah,
if in my example, the black was the mother's hair, then yes.
Okay.
That is an example. That also explains. So yeah, but my sister and I could both have black hair, but internally in the genetics, we could be different. But what we're expressing is the black hair. So I may be, so my gene, my chromosome may be capital B, which will express as black because they're both capital B. Hers may be capital B, small b. So technically she's not the same as me, but what gets expressed physically is the black hair.
So also
it's known as a recessive and a dominant gene.
Okay. And also, is this an exclusive process between the two genes within us, or is the two genes passed from the parents, or is there any influence of what we are structurally on what?
No, it's the parents. It's the alleles. It's what's coming from the parents.
Okay, so nothing that we can be proud of if we have something.
Pure hereditary. That's it. It's hereditary.
Got it. Thank you.
Okay. So this explains this report. And also just because I thought that it would be prudent, I purposely did not black this out because nowhere are we showing you dates. But this is another thing that I have had to talk about in court and in fact get a bail application based on the duration of a DNA test. So this is just interesting for you to see that this analysis was started on the 14th and 5 days later, the report was done. So when they say 6 months and 10 months for a DNA report, this is also possible under pressure. It doesn't take so long to create a DNA report.
Right, ma'am. How long does it take though?
Technically, not less than 3 days, technically 3-4 days if you're running it. Yeah, okay. So that's what you're saying. You're seeing a 5-day turnaround time, which is good. TAT of 5 is very efficient. But 6 months is not. The DNA, now this, okay, so let's just look at what this is. This is interesting as a sample because this is all the evidences that were collected from the victim at the time of her medical examination. So there was hair detected in her left hand. So she had pulled his hair, I guess. There was a vaginal smear, which we all know was done during medical processing. And both these were compared to the blood samples of the accused. And technically should have also been compared to the blood sample of the victim. I think one of the reports I've not included, but what I wanted to show you clearly was the framing of the sentences. Because if you look at it, it says that firstly, we're not used to seeing this. We're used to seeing numbers in every single row, which we're suddenly not seeing. And what this means is that we did not get peaks. In the gene mapper, there was no peak, so there's nothing to report. Once again, it's YSTR loci. So it's the same profile. And now let's just look at the opinion. The male haplotypes of the blood sample of the accused and the hair detected on exhibit 3, which is in the nail clippings of the hand of the victim, the semen detected on exhibit 4 from the vaginal smear slides, all match with the male blood sample haplotype. So that's basically once again saying that they're all again originating from the same male source. So what you've done is you've established that the male loci are all present in each of these samples. So interestingly, this is not a full profile, but yet with 5 or 6 loci showing matches they have made this report. So I just wanted to point it out to you. So one of the questions here would be that if you wanted to go and probe to this depth, is this a reliable report? Because there are a lot of loci that are not showing in this report. So why would that happen? And therefore, if it has happened, how reliable is in your interpretation? Shouldn't all of them show up? And the
Right.
scientific reasons for this not showing up is also sometimes you have badly maintained. So when we say decomposed bodies or burnt bodies or badly, we talk about scientific integrity. If that's not well preserved, if the sample is not well preserved, these are some of the problems we would face. I think that's the last slide. Yep.
All right.
So that's it for the program.
Yeah, that's it for the program, but that's not it from us.
No, we have more in store, but for this program, this is it.
Yes.
Right. So, sir, how do we conclude?
With a smile.
Right. Okay. So I'll just give
Feedback.
the access of the mic back to you all now. I can see Rajesh ji clapping and appreciating. So that's very, heartwarming to see. Thank you so much.
Thank you. I do think that we would like to hear feedback, especially if there are things that could be improved. It's always Ashish and my passion.
We are students of law and we always maintain. I mean, I always say that I am, there are so many things that I don't know. And the effort is, by these kind of sessions, one gets to learn also the way one gets to share something.
Me too.
Right, sir. Guys, you have the access. Any question, any feedback, any remarks, anything that you would want to share, you can share now.
Thank you so much, sir and ma'am. This was really an intriguing session. It has opened our eyes into something really new. We never thought that these things existed, and now we can explore these aspects further. Thank you for introducing us to so many facets of law, which we would have never come to know if we wouldn't have joined this course. And secondly, I would definitely like to remain in touch with you. Please share your email IDs in the group so that I will text you and remain in touch. And Ashish sir, if you ever visit Nagpur, please do let me know. I'll come and meet you personally.
Yes, and we can pick each other's brains.
Yes, sir. And even Raghav sir and Diva ma'am, but then I don't think you people visit Nagpur frequently. But then still, if you do, please do let me know.
So you visit Dehradun then, Ayushi?
I definitely. वहाँ पे तो आते मतलब बहुत. It is a hill station, right?
Yeah, something like that. Okay. Thank you so much, Ayushi. Rajesh, you have your mic on.
A phenomenal learning from both of you. Thank you very much, sir. Probably I'll fall short of the words to describe, the beautiful learning and my gratitude to you. And most of the words possibly have been used by Ayushi, so I really do not have anything to say now. And in fact, today's session was the, excellent session in the sense that even the cross-examination classes which we had earlier, this kind of thing was not touched upon, that one is a prosecutor, other is defense lawyer. So maybe in coming months, if you can think of something on different kind of cases and, educate us on how to go about cross-examination. Because this is something which you don't find, everywhere happening, and people are looking for, learning this cross-examination techniques. Think about it, sir. We will be grateful to you.
Yeah, and
this has become our USP. This is what we envisioned when we started working together, was that this is what we would do. We would make it practical and real, so that it's not theoretical and application. We wanted you to see it live, and it may not be perfect, but that is the attempt.
Once
Ashish,
again, thank you to both of you, sir and ma'am.
Thank you.
could you please conduct a course on the entire trial, जैसे कि how to use this cross examination in the final arguments, एक दो cases practically करके ऐसा छोटा सा course on the entire trial, including cross examination, including
So
final.
what I had spoken with Raghav, in fact, taking a leaf out of your suggestion. Remember last time you had last time I think it was you had suggested that how to cross-examine and how to ask suggestions and all of that. So that put a germ of thought in my idea. I mean, in my mind, a germ of idea in my mind. That why not have a short kind of a duration, maybe 3 or 4 sessions, because it really can't go beyond that, where we discuss all the laws pertaining to examination in chief, cross examination and re-examination, just 3 sections. Okay, and then we go on and have some of these mock drills, so the do's and don'ts of practical, how to prove documents, how to cross examine only on documents, how to cross examine on an eyewitness, how to cross examine a punch. So it could, so the opportunities combinations are tremendous. How do you cross examine a recovery punch? Because these are unique kind of things in criminal law. One doesn't replicate the other. So recovery punch is a particular methodology, a normal eyewitness is a particular methodology. So then the opportunities are endless. So we are really looking at designing such a course, and we'll certainly let you know when that happens.
And sir, how to use it in final arguments? जैसे आज का भी cross, how to use it in final arguments, DNA expert.
See, I will answer that question right now. I don't want you to wait till we design such a course. See, the final arguments are again the art of adding it all up. So when you look at your chart sheet, and this is what I tell all my interns and juniors who work with me, when you look at your chart sheet and when the charge is framed against the accused, that is the time when you must be ready with your skeleton of the final argument. So what I'm trying to say is that your meticulousness must be so much that you will have to see or project the final outcome of the matter and start looking at your final arguments. So if you have a narrative in mind which you want to tell the judge as a counter narrative to the prosecution case, only then can you start like a bead. So one bead you put another bead, and then the whole string of that necklace starts to appear. So the first witness, the second witness, if you look at it in a watertight compartment, then you will not achieve the desired results. Every witness is some way connected to another witness. So that connection you must find out, and whatever material you gather, it's like it's like collecting honey from a honeycomb. A honeycomb is huge and it has got irrelevant stuff also. So all you need to collect is the distilled sweet honey, and that is what we call as admissions in criminal law. So all those admissions that you collect, finally that honey, when you package it properly and you show it to the judge, and you can be able to persuade him easily.
Sir, I'll be waiting for that course. And the judgments also, sir, you had said.
Yeah, I shared some judgments with you. I'll share some more with Raghav.
Yes.
All right. So I think I'll just conclude with my gratitude to sir and ma'am for the course, for the learning, and how fun it has been to work on this. I think out of all the faculties, sabhi bahut zyada mehnat karte hain, but the kind of effort and the kind of heart that ma'am and sir put in these programs, it's just another level. And especially how adjusting and accommodating ma'am and sir, I have been very demanding from the participant side, ki aise karo, aise karo, aise karo. And most of the time I have been taken care of, and I'm really grateful to ma'am and sir कि आपने ये बहुत अच्छी compilation, एक बहुत अच्छा product बना के LCI पे रखा है, and all the people who will be visiting us on LCI, all the people who will be joining these courses, they're going to learn special things. And with that, all those who are in the class and who would be watching us here and there, do take up the other course that we did on evidence and procedure and the forensics that we had married it with. it was also a very special course. A lot of things that you will start getting about forensics, and then you'll be able to connect a lot with this. And also, don't think that your Tuesdays and Thursdays are now free. So you have a compilation to read in the days that you have, 2 or 3 weeks, and then we'll start with NDPS and forensics. So we'll again take your days, and do come for that also. This was me marketing for LCI, and that's it, I think. Thank you so much. Anybody else who would want to speak, you have the mic, and I'll wrap it up right here.
Thank you for sir, madam, and Raghav. Wonderful session. I didn't miss anything. I'm not a expert in this. I'm not a lawyer also. Just I went through this LCA, but just by mere asking 2 or 3 questions, one case was escaped from me out of this class in court. It was actually a rape charge, but actually it was a consent thing. 3 sessions before it was argued by madam and sir also earlier. It books or some that penetrative something and all, and the time, the duration for the semen collection and all. This girl, after 2 months, she revealed to her brother. Then the problem started. So it came. I asked this question. That's all. They went away. It happened in Trichy. Anyway, thank you.
Thank you so much, Kailash. You've been the sweetest participant that we have. And also, if you have any questions, aage jaake, you just put it in a mail, and then I'll get it addressed some way.
Yes.
Right?
Yes.
Okay.
Thank you so much, everyone. Good night, and good night. Thank you so much, sir and ma'am. Thank you so much.